Mister. Good morning, everyone. Welcome to today's class. Uh, my name is Fumi Ohana. I'll be your facilitator for today. As you can see, the course is business law, and today we'll be discussing registration of business and compliance requirements. I believe in previous classes you've discussed businesses and other things regarding related to business. Today we are going to look at the registration of business and compliance requirement. So what are the objectives of today's course? What do we want participants to learn today? So the first thing we want participants to have a basic understanding of the nature of the legal system in Nigeria, to enable participants to understand the legal regime and regulatory agencies regulating businesses, for participants to know the types of business organizations and steps in the formation and registration of businesses in Nigeria, understand the basic nature and elements in a commercial contract. So these are the objectives of today's course. So by the time we are done with this, these are the things we expect participants to have, not to really know everything, but to have a basic knowledge about these objectives. So what are our topics for today? Today's topics will be discussing the Nigerian legal system, relevant government agencies regulating businesses in Nigeria, types of business organization and legal implication of the various types of business organization. By the time we discuss the Nigerian legal system, you have a knowledge of how the Nigerian legal system works, what the Nigerian legal system is all about. Then we'll talk about the relevant government agencies regulating businesses in Nigeria. What are those government agencies that are regulating businesses in Nigeria? Uh, what uh, what are their functions, and how do you go about registering your business with these agencies? Then we'll talk about the types of business organizations and legal implication of the various types of business organization. By the time we look at the implications of this business organization, you know what type of business organizations you are running, or if you are not running any, what type you intend to run, and what are the uh, legal obligations. What are those legal implications for running that type of business organization? So we are going to look at all this. Then we are going to look at registration of business organizations. We are going to look at the registration of business organizations in detail. Registration of business organizations with the Corporate Affairs Commission. We look at it in detail, and you have an idea of how to go about doing such from your using your device or using any accredited agent. Then finally, we'll discuss the law of contract, because we need to discuss this because once you go into a business, your everyday dealing has to do with contract. You're entering into contract. So because of that, you need to have a basic idea of what you are entering into and what you are dealing. What are the consequences of what you are entering into? So the first topic is the Nigerian legal system. When we are talking of the Nigerian legal system in this sense, it consists of the totality of laws or legal rules and legal machineries which are obtained within Nigeria. Once we say Nigerian legal system, we're talking of the laws, the rules, the legal machineries that are obtained within Nigeria as a sovereign country. The legal rules, which we have the constitution, the penal code, the criminal code, the karma, everything, everything law in Nigeria. Then we talk about the agencies, the courts that are there to enforce. There must be a machinery to uh, that will ensure enforcement. So courts and various government agencies are there to ensure that people do not only know of the law, they also obey it. Where there is breach, they are also enforced. So it must be backed up by some sort of mechanism for sustenance of its binding nature to ensure that people obey the law. Because without a mechanism to ensure that people obey the law it will just exist in a vacuum. There is no need for having the law. So what is law? Every day we have various rules and regulations regulating our daily lives. In our various homes, we make rules. Don't eat uh, or don't you have rules for table manners, you have rules for how your children should conduct themselves in the house and the rest. So these rules are things that govern our relationship with other people. So, but for the purpose of this class and 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 to the law profession, is more interested in the narrow. We are more interested in the narrow and guarded meaning of law, which is the rule of human conduct tacitly or formally accepted by people as binding and backed up by some mechanism for the sustenance of its binding nature. Because once is a law, rule of human conduct, guarded meaning of law as a rule of human conduct, tacitly or formally accepted by people as binding and backed up by some mechanism for the subsistence of its binding nature. So when we make these laws, for them to have a binding nature, there must be punishment. So this is what we are saying. Rules are there to regulate the conduct of human beings within a society or within a family or within a class. But for such rules to be effective, there must be a mechanism for the sustenance of its binding nature. That is why we have in place punishments where you violate certain rules. So as we go about we discussing this rule, we discuss civil law and Nigerian criminal law. So all these things are things that we'll look at, and these are the laws that are governing that these to ensure that human conduct are done in such a way that will not be harmful to other persons. That's why we have law. So what are the sources of these Nigerian laws? First, we'll look at the common law. Well, when we say common law, these are laws that were formed, administered, and developed by the old common law in England. Back then in England, they don't used to have something called a written law or something like that. So it was based on the custom of the people, just like we have our customary law. So what they did back then was the king then will send itinerant justices to various communities in England. So once they go to England, once they go to these communities, they administer justice, get it based on the custom and traditions of the people. So after the various itinerant justices have gone out and administered justice, they will come back and sit down and look at the various custom and traditions of the various communities they visited. So from there, they will discuss and say, this one is good, this one is good. From there, they evolve a law called the common law. And a common law court was also developed for the purpose of administering that law. So this common law also form parts of our law as a country in Nigeria. Because before we gained independence and the rest, the British were imposing such laws that were applicable in England to us in Nigeria. So after the British have left, that we still are using this law up to date. They still form parts of our law. So, however, this common law back then in England too became so rigid and so complex. It became more concerned about it was concerned more about administering more about forms and procedure rather than administering justice. So let me give you an instance of common law you back then in England. Common law is like, for instance, they say, don't come to work by 8. If you come to work by 8, you'll be sacked. So the form is the law is don't come to work by 8. If you come to work by 8, you'll be sacked. There is no grace for you to come 5 minutes past 8. Once you come 5 minutes past 8, under common law, 8 is 8. If you fail to come, so they will not even consider whether there was delay traffic riot. No. They don't care. Common law says you should come by it, come by it. Another example of common law is maybe agreements that are meant to be in writing. Common law says this particular agreement must be in writing, and you decide not to have it in writing. Under common law, such agreement cannot be enforced, because common law was more concerned about the form and procedure rather than at the administering justice to parties involved in that contract. So uh, um, because of that rigidity and the fact that common law is more concerned about procedure, parties were dissatisfied. So as a result, parties started petitioning the crown. And once parties petition the crown, there's the King's Council. And the King's Council are those ones are the King's advisors. And part of the people advising the king back then was the Chancellor. And the Chancellor also was a priest. So once people are back then in England who were dissatisfied with with whatever judgment passed by common law, we petitioned the crown, and it was the Chancellor that will listen to such petitions from such people. So as a result, they developed the doctrine of equity. So it leads us to the second uh, source of Nigerian law as we have it here, doctrine of equity. So equity, unlike as we know it in the normal parlance, that is fairness, here in this class and in this context, when we say doctrine of equity, we are talking about these are laws that mitigate the harshness of common law. So is doctrine of equity came in to mitigate the harshness of common law. So that is why it's common for you to hear maxims like he who comes to equity must come with clean hand. Equity looks at the intent and other equity acts in persona and all these rest. These are doctrines that were evolved many years ago in England. And these doctrines are still applicable in our laws in Nigeria. So they still form parts of our law. So, for example, the maxim equity acts in persona is there is a remedy in law called specific performance. So that specific performance is what is what we regard as equity acts in persona. So in our subsequent discussion, we will discuss what specific performance is. So then we have the Nigerian legislation. As the name implies, these are laws that are formulated within Nigeria by the National Assembly or the State House of Assemblies. These ones we know they form part of our laws because every day there are plenary sitting in the National Assembly or House of Assemblies in various states. They are making laws for their states, laws pertaining to national issues exclusive to the National Assembly, laws in the Constitution that are concurrent, which can be deliberated on by the National and House of Assemblies of various states, are all being deliberated. So these laws are the ones that are developed by our National Assembly. For instance, laws like the Advanced Fee Fraud Act, the laws like Criminal Code, and the rest. All these are Nigerian legislation. So as usual, they will pass first reading, second reading before they will be passed into law, then assented to by the president. Like the recent, for example, is the Companies and Allied Matters Act, which was recently passed. Is a good example of Nigerian legislation that I can give you, and others that numerous laws. When you check laws of the Federation of Nigeria, you just see so many of them. Those are enactments of the National uh, Assembly, or in the various states, they also have their own state laws. So we have customary law. When we are talking about customary law, we are talking about the customs of obtained in different localities, just like common law in England, which I said it is the customs and tradition of the people back then in England. So in Nigeria, we also have our own customary law. But unlike England, that they've evolved theirs to be codified, in Nigeria, we've not done so. So we are still underestimating ours, and we are still referring to them as customary law, while we've coded that of England to form part of our law. But regardless of that, customary law still forms part of our law, because there are decisions of the Supreme Court of customary law, especially for instance, the Benin custom of inheritance. There is a local classicals of Idehen versus Idehen that decides on the Benin customary law. So they still form parts. That decision was based on the Benin customary law. That is to show you that custom of the people within that particular locality still forms part of Nigerian law. It is not discarded. So these are customary law, a body of customs and traditions which regulate the various kind of relationship between members of the community in the traditional settings. So these also form parts of our law, and they are still applicable. So we have judicial precedent and case law. The function of the judiciary is to interpret the law. So in the course of interpreting this law, the judiciary too are also making the law. Once a legislation is passed and accepted to by the president and it becomes a law in Nigeria, sometimes the application of such laws might be problematic, and it might lead to problem between parties. So they will go to court and seek interpretation. So once the court interprets the law, that becomes also part of the law. That is why it's common for you to hear cases, lawyers in court saying, in the case of so, the courts decide. So you see, even though it's not written as part of our law, but they become part of our law by that judicial interpretation by courts. That is why we have hierarchy of courts too, which we will discuss subsequently. So this precedent also, once the Supreme Court makes a decision in a particular matter, it becomes a law. So lawyers will always refer to that as the law, even though there might exist a Nigerian legislation on such issue, but it is the interpretation of court that will be used in case it still goes back to the court to to decide on that particular issue. Then we have international law. When we say international law, we're talking about laws that are governing different states, that regulates the relationship between different countries. And these international laws too also form parts of the Nigerian law, because we have conventions that were ratified and domesticated by the Nigerian legislation, and as such form parts of our law. Example is the United Nations Declaration on Human Rights, the African Charter on Human Rights. These are international law. These are not, but with, especially when you go to chapter 4 of the Nigerian Constitution, which has to do with fundamental human rights. You see, these are things we got from the African Charter and the United Nations Declaration of Human Rights. So these are all there for us, and they form parts of our law. And one thing, international law could be private, it could be public. Private in the sense that it's governing between it's there to govern relationship between individuals of each state. That is governing the relationship between a citizen of Nigeria and a citizen of Niger. That is private international law. Then we have the public international law, which is between the states. That is, this one is dealing the states. So these are the sources of Nigerian laws. Then we have the uh, okay, strictly, sorry, let me go back to sources. The Sharia law too is also part of the Nigerian law, but in Nigeria, the Sharia law too is also considered as part of the customary law. So then we have the Nigerian courts, the hierarchy of the Nigerian courts. We have the Supreme Court. The Supreme Court is the highest court in the land. It is the final court. So once the Supreme Court decides on an issue, it becomes the law. This takes us back to what we discussed, precedent and case law. For instance, you will see they will start cases in election tribunal or in high courts. Because let me use example of election tribunal because it's the common thing. And let me use the example of Imo. Like in the case of Imo State, we see they started from election tribunal. From election tribunal, they went to Supreme. They went to Court of Appeal. From Court of Appeal, Election Tribunal, the decision was in favor of PDP. Uh, they went to Court of Appeal in favor of PDP. But when they went to Supreme Court, which is the final court, the court decided that the candidate to be the governor in Imo State is the APC candidate, and that decision became final. There is nowhere you can appeal the decision of the Supreme Court. The Supreme Court is the apex court of the land. Then we have, next to the Supreme Court, we have the Court of Appeal. As the name implies, Court of Appeal. It's appeal from the various courts of records goes to the Supreme Court, except for some uh, um, except for some, sorry, with respect to Supreme Court, not Supreme Court too is also an appeal court in the technical sense, but because you it's decisions of lower courts that will go to Court of Appeal before they go to Supreme Court. But there are other matters that the Supreme Court has original jurisdiction. That means the Supreme Court can entertain such matter in the first instance without going to a lower court. But that one is by the way. Then we have the Court of Appeal. Then the Court of Appeal entertains appeals from the Federal High Court, State High Court, Election Tribunal, Investment and Securities Tribunal, Tax Appeal Tribunal. All these appeals goes to Court of Appeal. So the Court of Appeal will decide if parties are dissatisfied with the decision of Court of Appeal, they'll go to Supreme Court. But there are some matters that end at this Court of Appeal. This has to do with National Assembly matters and State House of Assembly matters. They end at the Court of Appeal. You can't go to Supreme Court. Then we have the Federal High Court. The Federal High Court, by virtue of Section 251 of the Nigerian Constitution, listed all the matters which the Federal High Court has the jurisdiction. When we say jurisdiction, that means we are talking of the Federal High Court can hear the matter, because it's not, if you want to institute a matter in court, it's not just any court you go to and say, I want to institute that matter. You have to look at what is the subject matter of the case, the jurisdiction, the subject matter jurisdiction. You look at other things. You have to look at the facts of the case before the lawyer will decide, okay, I want to go, this matter is for Federal High Court, this matter is for State High Court, this matter is for National Industrial Court. You cannot just say, let's go to court and you go and institute your matter in any court. You have to look at the subject matter to decide which court has jurisdiction. So Federal High Court, like by Section 251, has jurisdiction over matters normally involving federal agencies, not matters of contract or matters involving federal agencies like Nigerian Port Authority and other, or matters related like CAC matters. If you want to sue CAC to court and the rest, these are things you institute at Federal High Court, because one, the CAMA is the Federal High Court that has jurisdiction to entertain all matters relating to CAMA. So any issue that is arising out of CAMA is the Federal High Court by virtue of Section 251 of the Constitution. You see the Constitution listed out all the matters you can bring to Federal High Court. Then we have the State High Courts. These are courts that are found in the various states of the country. And the FCT2 has its own equivalent, which is the FCT High Court. And these state high courts have criminal or limited jurisdiction in criminal and civil matters. However, those matters must not fall within matters which are within the jurisdiction of the Federal High Court, and they must also not fall within the jurisdiction of the National Industrial Court. So they entertain all matters, and if parties are dissatisfied with the decision of the Federal High Court or the decision of the State High Court, they appeal to the Court of Appeal. Then we have the National Industrial Court. The National Industrial Court is there to entertain labor matters between trade unions, between employer and employee. So you see, once there are matters between employer and employee, master-servant relationship that borders on the how the relationship was terminated and the rest, you go to National Industrial Court. We have the Sharia Court, which is there to entertain Islamic personal law. Parties who have subjected themselves to Islamic personal law can go to Sharia courts for their matters to be decided. Then customary courts, as I've spoken before, I the customary courts are there to entertain matters on the custom and traditions of the people of that particular locality. So whoever is presiding over that court must be somebody that has the knowledge of the custom and traditions of those people, so that he will be able to adjudicate on such matters. Then we have the magistrate court. These are the Sharia courts, the customary court, although Sharia courts in some states, they are of grades, and you find Sharia courts mostly in the north. Then that's where you find Sharia courts, mostly in the north. So you see customary courts, then we have the magistrate court. The magistrate court has jurisdiction to entertain criminal and civil matters too, but there is a limit to their jurisdiction. There are certain matters they cannot entertain. This depends on the state too, and this magistrate court can be of different grades in different states. And magistrate court can also be a district court. It's just a matter of nomenclature. In the north, you see a magistrate court is also referred to as a district court. That means in the north, it's magistrate court to entertain criminal matters, district court to entertain civil matters. Even though it's the same court, it's just and the same judge. It's just change of nomenclature. If you are bringing a civil matter, district court. If you are bringing a criminal, that is in the north. Then the area courts, customary courts, they adjudicate on the same matters. Area courts in the north, customary courts in the south and west, they all entertain customs and traditions. That's the jurisdiction of area courts, even though in practice sometimes it's not what we see in writing that normally we experience in writing. So we look at civil law now. When we see civil law, we're talking about law that govern the relationship between citizens. So it confers obligation towards citizens, towards each other. So, like for instance, now civil law is there to govern your relationship with your neighbor. If you have any disagreements with your neighbor, maybe be it contract, be it defamation, be it battery, be it passing off, all these are civil wrong. What is defamation? Defamation simply means when you either say or write something about somebody that is false. So that's defamation. So it can be slander, it can be libel. Trespass is when somebody is in exclusive possession of a property and somebody decides to go and disturb his possession, or decides to go and say he wants to do something on the property when he knows that such person has exclusive possession. So you can sue. So these are civil wrongs, and the civil law is there to correct such wrongs. So it governs the relationship between individuals and it confers obligation towards each other. That is why we have civil law. Normally, um, they are not written. Civil law are not written. They are mostly based on the decisions of court and the rest. Even though we have general principles, especially general principles of contracts and other things, and Sales of Goods Act and the rest, all this we have, but they are meant to govern relationship between persons, between citizens. Then we have the Nigerian criminal justice system. When we are talking of the Nigerian, we are talking of the criminal system, especially. One thing with criminal law is that there is always a statute to tell you not to do this, not to do that, not to go about doing this, not to do that if you do that. And there's a punishment too. When you breach any law or when you violate such law, there's always a punishment. That is why we have the Economic and Financial Crimes Act, we have the Advanced Fee Fraud Act, we have the different acts governing uh, uh, relationship of individuals with the state. And because the penal code and the criminal codes are there, they said don't murder, you go ahead and murder. It's an offense against the state. And one thing about criminal law is that it is the state that prosecute. That means individuals, that is private lawyers, cannot say they want to prosecute another person except when they are given fiat by the Attorney General of Nigeria. Then, with respect to civil law, that is where you see you go and meet a lawyer and say, okay, come and institute, this person collected my money and he has refused to pay, or we've entered into an agreement with this person and then you say, I want to go to court. These are civil wrong. Then you get lawyer, you see him to court. He gets, either he represents himself, because the Legal Practitioners Act says that a litigant can represent himself in court, or he can hire a lawyer. But if you decide to go to court as a litigant, you don't know the procedure, so you need a lawyer to represent you. So this is it about the Nigerian legal system. So we are going to look at the relevant regulatory agencies. Relevant regulatory agencies regulating businesses in Nigeria. And what are these agencies? We have the Corporate Affairs Commission. We are going to discuss the Corporate Affairs Commission later in detail, then the Federal Inland Revenue Service and various states' internal revenue services too. We'll discuss that in detail. Then for the Central Bank of Nigeria, we're going to discuss this in brief. The Central Bank of Nigeria is the apex financial institution in Nigeria. It is there to dish out policies, how banks will go about doing businesses with customers. They are there to ensure the overall growth of uh, the Nigerian economy. The central bank was established by the 1958 Act of the CBN, but the current legal framework governing the operation of central bank is the CBN Act of 2007. That's why you see, was it last month, CBN reduced the lending rate in Nigeria to 11%. They're there to ensure policies, to do policies that will make the Nigerian economy to be more favorable. You see CBN banning things, banning importation of stock, CBN regulating, giving out dollars and the rest. All these are the work of CBN to ensure that the overall growth of the Nigerian um, economy. And CBN is also there to ensure how banks, relationship between customers and banks. Then we have the Asset Management Corporation of Nigeria. The Asset Management Corporation of Nigeria too was established by the AMCOM Act of 2010, though it has been amended in 2020. So AMCOM is there. AMCOM is to assist bank, is to ensure liquidity flow in the Nigerian economy. That means AMCOM AMCOM is there to ensure liquidity flow within the Nigerian banking system. That is why, if let me give you a scenario of how AMCOM acts. For instance, if somebody borrows money from a bank, let's say Mr. Johnson borrows money from a bank, and Mr. Johnson fails to pay that money, and as a result of his failure to pay that money, is affecting the cash flow within the banking system in Nigeria, because the bank needs that money to lend it to another person. So where it has become a non-performing loan, Mr. Johnson is no longer paying that loan. What AMCOM will come and do, it will look at the books of that bank and say, okay, what are the non-performing loans you have within your bank? What are those bad assets you have? AMCOM will come and buy those loans. So now I will pay the bank. That means the money Mr. Johnson borrowed from that bank, AMCOM is paying the bank back their money. So by such an act, it ensures liquidity flow within the Nigerian banking system. So AMCON will go after Mr. Johnson. So that is why AMCON is there to management and severance of toxic assets within the banking statement. So it is the responsibility of AMCON to ensure the management and disposal of toxic assets of the Nigerian banks, which also covers non-performing loans. So that's the work of AMCON. Then we have the National Agency for Food and Drug Administration Control. We also discussed that in detail later. Then we have the Standard Organization of Nigeria. We'll discuss that too in detail later. Then we have the Federal Capital Development Authority. For those based in Abuja, the Federal Capital Development Authority is in charge with in charge of anything land in Abuja here with its agency, with the ages. So if you have any business that has to do with land, you need to acquire land, you need to do this. Even though you're acquiring the land from another person, you need to conduct search, you need to check whether that land is genuine, they are not selling another person's land to you, and all other things is the FCDA you go to, or you are looking for approval, all other things, you use the FCDA within Abuja. But if the business or you intend to branch out to other states, you can as well contact the Ministry of Land or any land agency created for that particular reason. So now we are going to look at the Corporate Affairs Commission in detail now. The Corporate Affairs Commission. The Corporate Affairs Commission was established by the Companies and Allied Matters Act of 1990, even though it has been amended severally. And the recent amendment is that of the 2020, the recent amendment that has generated a lot of controversy. So is the CAMA that establishes the Corporate Affairs Commission. And the Corporate Affairs Commission is the custodian of CAMA. So anything Corporate Affairs Commission is doing must be in accordance with the CAMA. So businesses, registration of businesses, companies, incorporated trustees, uh, of with the recent amendment, LLP, which is limited liability partnership, all falls within the purview of Corporate Affairs Commission as provided by CAMA. So, what are the functions of what is the responsibility of Corporate Affairs Commission, the CAC? It is a regulatory agency in charge of registration, regulation of business and known business organizations such as companies, business names, and incorporated trustees. So these are the functions of, this is the responsibility of CAMA. And what are the functions? Section 7 sub 1 of the CAMA, the 2020 as amended, has provided for the functions of CAC, which is regulation, supervision of the regulation, even they regulate those companies that have been incorporated, then supervision of the formation. At the stage of formation of the company, they ensure that you follow the laid down procedure for such. Incorporation is their responsibility to incorporate new companies. They don't just incorporate. After incorporation, there is management, because there are things you need to file, especially annual returns once you are running a business, and it has to be with the CAC. Annual returns to show that your business is a going concern and is filed annually, though after 18 months of incorporation when it's a new business. These are things that I'm just mentioning. These are, by the way, that the when you incorporate your business, you contact the lawyer or you contact an agent. These are things they'll put you through. Then you have the management. They manage those, they ensure that these companies are run in accordance to their objects, or any incorporated trustee, then winding up of companies. When you feel your company is no longer a going concern or you want to wind up the company, it's all the responsibility of CAC. Then they maintain a company's registry in all states of the federation. That's for you want to do change of shareholders, change of directors. All these are responsibilities of the functions of CAC. It also carry out investigation into the affairs of the company if the situation demands. Why, if where there's issue of abuse of power or minority shareholders are whatever it is, CAC has the power to carry out investigation. So the recent rancor and the 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 issue of CAC and incorporated trustee. When I say incorporated trustees, I'm talking about churches and NGOs, because they are incorporated under, I guess, PASI of CAMA, which has to do with incorporated trustees. So those incorporated trustees, this recent amendment, this particular power to carry out the investigation has generated a lot of controversy, especially in churches that still CAC can take over churches. And to let me just say this, before they can take over any business organization or any church or anything, they have to go to court first. It has to be with order of court. So other parties, in accordance to the provision of the constitution, must be given fair hearing. Other parties too must be heard before the court can make an order for CAC to take over any church or to take over any business where the business is going out of is not running such business, or the organization is not running such organization in accordance to the objective of that particular organization. So these are the functions of CAC. Then we have the Federal Inland Revenue Service. The Federal Inland Revenue Service used to be an arm of the Federal Board of Inland Revenue, the FB. It used to be an arm of the FIBR, which is the Federal Board of Inland Revenue. Sorry, it used to be an arm. But however, by the 2007 Establishment Act, the Federal Inland Revenue was made an autonomous organ. The Federal Board of Inland Revenue is just there to give it general policy guidelines. So the Federal Inland Revenue Service, by the Establishment Act of 2007, is charged with the responsibility for the collection and administration of federal and corporate taxes. That is why we're talking about FIRS. FIRS has generated how many billion. They take pride in generation of money they've done to federal government, because this is their job, the collection and administration of federal and corporate taxes. They just don't stop at the administration and collection and administration of federal and corporate taxes. They also enforce and administer law that that the various laws that regulate taxes in Nigeria. They administer and also enforce. They also control such taxes too. So example of such taxes are the value added tax, the personal income tax, the company um, income tax, the stamp duty act. They regulate the stamp duty act, which has to do with the stamp duty act, and they regulate the value added tax act, the companies the personal income tax act, the company income. So these are laws that are administered by the Federal Inland Revenue Service. So we are going to look at the VAT, which is the value added tax now, because it's something which is common once you are running a business. As you can recall that the federal government has increased VAT from 5% to 7%. This is to show you that VAT is an essential tax. So we just dwell on, for the purpose of this class, we just dwell on VAT. And VAT, as you know, is the consumption tax that is levied on a product or services at every point of sale. Is repeatedly levied on a product or services offered at the point of sale. So anytime you are being offered a service or you are buying a product, you see VAT is included. It's common for you, after making a call, you see the network saying VAT included. After making a call, VAT included. After each call, VAT included. So these are, because VAT is a consumption tax that is levied repeatedly. That is why it's being we are being taxed repeatedly for every product we buy and for every service we are being offered for. We are being offered. So that is why if you are running a business, you need to go and register to get your VAT registration number, and I register with the local VAT office, which is we know is the Federal Inland Revenue Service, so that you can be remitting your tax. You collect the tax on behalf of FIRS and remit to them, be it monthly, be it weekly. So everything is there. Though it's not all all things that are vatable, as we say in law. Vatable is not all products, it's not all services that are vatable, especially when it comes to the issue of rent. Recently there was a decision that was passed that you cannot collect VAT on rent. So there are some things that are exempted from VAT. So we're going to look at the Standard Organization of Nigeria now. So when we talk of the standard, is the sole statutory body that is vested with the responsibility of standardizing and regulating the quality of all products in Nigeria. Once you want to go into manufacturing, manufacturing of doors, manufacturing of tables, manufacturing of chairs, manufacturing of uh, electronics, and the etc., with the exception of food, drugs, water, those things that are within the categories of products that is meant for NAFDAC to administer, which we will look at subsequently, then you need to be certified by the Standard Organization of Nigeria to ensure that your products are of good standard. That is why we have the Standard Organization of Nigeria. It is common for you to buy a product and you see the sign Standard Organization of Nigeria with a tick. That means to show you that that person has that product has been certified or by the Standard Organization of Nigeria. So it's common for you to see them also, the officials of excuse me, the officials of Standard Organization of Nigeria raid markets to classificate products, classification of products of very sellers that have not been certified. So what are some of the functions of this organization? So the statutory function of the statutory function of the Standard Organization of Nigeria includes to investigate the quality of facilities, materials, and products in Nigeria and establish a quality assurance system, including certification of factories, products, and laboratories to ensure reference standards for calibration and verification of measures and measuring instruments. So all our measuring instruments, tapes, anything that is used for measurement in any profession, it has to standard organization has to ensure the reference standard of such measuring equipment to comply to compile an inventory of products requiring standardization. So those before you go and say I want to certify my product with the standard organization, you have to look at their inventory, whether that manufacturing has been is in the inventory of Standard Organization of Nigeria, and it can be certified by them to foster interest in the recommendation and maintenance of acceptable standards by industry and general public, to advise states and federal departments on specific problems relating to standard, and also they advise department of government on specific relating to standard. So they also have the powers of seizure, classification, destruction of substandard products, including powers to seal off premises where defective products are manufactured or stored. As I as I said earlier, it's common for you to see their officials go to market to classificate products. So this should serve as a warning for you that where the product falls under the inventory of products that are supposed to be certified by the Standard Organization of Nigeria, then you need to go and certify with them to avoid uh, any problem to your business. So that is it with the Standard Organization of Nigeria. Next, we are going to discuss registration with Namza. So at this stage, we are going to look at those category of products that are registered with NAFDAC, and not for you to go to the Standard Organization of Nigeria and say you want to certify that product. So by the act creating NAFDAC, NAFDAC has the mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, the registration of the categories of products such as foods, drugs, medical devices, and cosmetics. So these are the products that are within the categories of NAFDAC to administer. So all businesses dealing in food and related products are subject to regulation by NAFDAC. For it is unlawful to market any drug or consumable goods in Nigeria without registration with NAFDAC. So the essence is once you want to go into production of foods or you're into production of foods or drugs, medical devices or cosmetics, go and get your NAFDAC registration number. Go and register with NAFDAC. After your registration, you'll be given your NAFDAC registration number. Though registration may differ for different categories of products, which includes food and water, drug and medical devices, herbal and cosmetics, medicine and biologies, chemical, veterinary products, and narcotics. These are the categories that are within the uh, purview of NAFDAC to administer. So once these products fall into these categories of products, once what you are into or what you are producing fall into categories of products, it falls into this category of products listed by NAFDAC, then you need to go and register. Though there's specific documentation may vary, but the depending on what you want to register with NAFDAC will determine the kind of form or what you register. So there are broadly a two-stage process of registration, which is application for approval to bring in samples, then application for full registration of products with NAFDAC, which you have to do whether locally or manufactured product. So basically, is you have a product you want to and you need to register with NAFDAC. The type of product you want to register will determine the kind of form you fill with NAFDAC. It will determine the kind of form you fill with NAFDAC and what the requirements will be. So I can't start saying, okay, for food and drug, this is, but I'm going to give you key requirements. And what you need to know when you want to register with NAFDAC, there is application to bring in samples except where your product is locally manufactured. Then there is application for full registration of products, whether locally manufactured or imported. That's the second, the stage of where you fill the forms, you do the payment, and the rest. So in the course of this class, we will look at the what are the key requirements. What are the key requirements? Because we cannot bring out a particular product and tell you this is the requirement. We cannot. We are going to take the whole day discussing each product or each. And moreover, we cannot exhaust all products. So we are just going to look at the key requirements. What are those key requirements? Where you are importing, what are those key requirements where it is locally manufactured? Before we start discussing this, I want to bring to your notice that it's not all products that is different. Where it is locally manufactured, your documentation is different. But for the purpose of this class, we just joined everything together. Where you want more details and you want more explanation, you can contact the NAFDAC office where they will give you more broader explanation. But for now, you get to know what the key requirements are. Like for drugs, for instance, drugs as application is on single product basis. That means where you have, for instance, you have different drugs that you want to register. Let's say you have uh, uh, a drug for headache, you have a drug for stomach ache. If you want to register that drug with NAFDAC, you cannot, if you want to register those drugs with NAFDAC, you cannot join the two drugs together and say you want to apply for one NAFDAC registration number for the two drugs. Application is on a single product basis. That means for the drug for headache, is you make a separate application. For the drug for stomach ache, you make a different application. That is why he said application is on single. Hey, it has gone off. Sorry, sorry. Let me still go back. Uh, Let me still go back to written application stating name of manufacturer. I never knew my mic was not unmuted, so I'm sorry about that. The written application, what I said is the written application stating the name of the manufacturer. That means in your application, you must state the name of the manufacturer. If you are the manufacturer, you state your name. If it is a brand, let's say for instance, Pfizer, and the product is being manufactured in India, you have to state that it's Pfizer. Then you complete your Nafta application. Then you bring in your certificate of incorporation with the Corporate Affairs Commission if it is a company, along with the application. You know, in law and by the provisions of Karma, where a company is not a Nigerian company and it wants to come to Nigeria, except it is given an exemption, it must register a company in Nigeria. It must register that company in Nigeria for it to be able to carry out business in Nigeria. So that is why they will even ask you for certificate of incorporation of that company. So you also attach 5 copies of the product dossier. And what I said product dossier is just collection of the various documents and data. Because as you are producing a drug or something, you must have carried out your research, everything, the data concerning the research, development, safety, and efficacy of the licensed products. All this has to be considered by NAFDAC before your product is registered. Then you have 3 packs of the product sample, a notarized original copy of the duly executed power of attorney from the product manufacturer. When we said power of attorney, I know some of you are aware of what power of attorney is. Power of attorney is just a document stating that so person should do something in my state. That means you are giving power to that person to what you can do. That person should be able to do it on your behalf. So, in application to NAFDAC, especially when you are importing a product, that's why I use Pfizer. Let's say the product is manufactured by Pfizer in India, then you need power of attorney donated to you by Pfizer, which you attach to your application that, okay, Pfizer has given me the power to import and distribute this product in Nigeria. So that is just, and that power of attorney has to be executed by either the Nigerian mission or Nigerian embassy in that country. In the absence of a Nigerian mission or Nigerian embassy in that country, then you can take it to any ECOWAS mission. In the absence of that ECOWAS mission, you can take it to a British High Commission. That is why we also have the certificate of manufacture, where there is issued by a competent health or regulatory authority in the country of origin and authenticated too by the Nigerian mission in that country, or where there is no Nigerian mission, a British High Commission or an ECOWAS country mission will authenticate it. So that certificate of manufacture too has to be authorized by an agency in India that is in charge of authorizing or that is playing similar role as NAFDAC. So that particular agency too has to certify that that particular drug produced by Pfizer in India is good. Before you can start, you have to bring such certificate to NAFDAC, attach same to your application. Then the contract manufactured or contract manufacturing agreement properly executed and notarized by notary public in the country of manufacture. That is when you are importing. In the absence of power of attorney, the contract manufacturing agreement too will also serve. Then current World Health Organization good manufacturing practice certificate for the manufacturer authenticated by the Nigerian mission too will also serve. Then certificate of pharmaceutical products duly issued and authenticated. Current superintendent pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, where you want to distribute drugs. In this case, you want to distribute drugs because if you can recall, we said they are not only in charge of manufacturing, but advertisement and distribution. So in Nigeria, if you want to do, you need, and as I told you earlier, that we what I did there is to combine everything together because we cannot exhaust everything. For details, is you go to the nearest NAFDAC office close to you, or you use an agent who will help you process this application. Then, and I have a good news to you too. Also, where you cannot visit NAFDAC, they've begun online registration, which we'll look at after I'm done discussing these procedures. Then certificate of registration of brand name with trademark. Let's say, for example, Pfizer, you're importing your product manufactured by Pfizer in India. So what you need a trademark registration. Pfizer's trademark must be registered with the Nigerian Ministry of Commerce. If you want to register, if you run a business and you want to protect your trademark, I know you know what trademark is. You know MTN, their logo is MTN, and they have a trademark with MTN with red with M and the T with red under. That's MTN's trademark. The trademark can also serve as a trade name, like Coca-Cola. You know their trademark, like Nike. You know their trademark is that good. So any person who is selling any product and is taking using the Nike good, Nike can sue him for infringement on their trademark. So if you are running any business, you have to register your trademark to protect your trademark from from being abused or somebody exploiting your goodwill in your business. That is why the Ministry of Trade and Commerce is there for you to register under the department for such. There's a department created for such to register your trademark. So for you to make an application to NAFDAC, if it is a brand name, such name must have a trademark registered with the Ministry of Commerce. Then letter of invitation for manufacturer to inspect factory abroad. Where you are importing, there must be letter of invitation given to NAFDAC to go and inspect that factory abroad. Let's say that Pfizer factory in India has to be inspected by NAFDAC. Then you pay the applicable fee. So, as I was discussing earlier, I said we talked a little about the new online registration introduced by NAFDAC. They called it the NAFDAC Automated Product Administration and Monitoring System. That is what they call it, NAFDAC Automated Product Administration and Monitoring System, and abbreviated as NAPAMS. So what you just do, you go to www.napams.org. Once you go there, once you enter the address on your phone or computer, you just, since you are a new user, you sign up or register an account as a client. After you've signed in or log in with the registered account, you complete the application form. I believe the application form will, depending on the kind of product you want to register, it will just bring out the form for you to fill. And basically, what you would have filled manually is what you just fill online. Then you make payment after the completion of the application form, then processing the application, then you obtain your certificate. But it's not as, I'm just, I know it's not going to be as easy as I've said it, because it's something they just began recently. We don't know how effective it is, but I believe as time goes on, it will become more effective. So it will save people the stress of going to their office to go and obtain form. It will save people the stress of using agents and the rest if you can do it yourself. And in such a case, I believe they will make provisions for helplines for people to contact where they are having problems registering their product. And this registration, this was, I guess was just introduced last 2 months. They just started, so I don't know how effective it is. But if you want to register, you can still go to their office, pick up the form manually, and do your application, or you can go to www.napams.org. where you see steps. There's also they provide steps for how to go about registering there. So that is it with registration with NAFDAC. So now we are going to look at the types of business organization and the legal implication of the various types. What are the types of business organization and what are the implications? So when we see business organization, we're talking about a legitimate venture to make profit. Any legitimate venture, emphasis on legitimate. You know, we said legitimate venture to make profit. Don't go and engage in any illegitimate venture and said it's a business organization. You are running a business. That is an illegitimate business organization. But where you are running a legitimate venture to make profit, emphasis on profit, you want to make profit, then you are running a business organization. So what are these types of business organization? We have the sole proprietorship, the partnership and company. Sole proprietorship, partnership and company. So what is sole proprietorship? As the name implies, sole proprietorship. So one person. That means a business run by one person. He makes all the decisions himself. He enjoys the profit himself. He If he dies, the business dies with him. So that's sole proprietorship. Once you decide to run a sole proprietorship, what are the implications? One man business. What is the implication of running a one is that the person has an unlimited liability. His liabilities are unlimited. Where he borrows, he will repay personally. That means where you borrow, for instance, let's use Mr. Johnson business venture. Mr. Johnson is running Mr. Johnson business venture as a sole proprietor, and Mr. Johnson decides to borrow money from Skyron Bank, Skyron Bank PLC. Skyron Bank PLC want to recover their money from Mr. Johnson. What they will do is they can, after they've obtained judgment in court, they can go after his personal belongings, his cars, his television, his beddings, anything they can find, they can lay their hands to recover their debt. They will do it because Mr. Johnson is running a sole proprietorship. That's the legal implication of running a sole proprietorship. Aside the fact that if he dies, the business also dies with him. The sole owner is personally liable for the debt and liabilities of his business. He's solely liable. He cannot say it's his business. Mr. Johnson cannot say it's Johnson business. He venture that is liable because the name of the business is Johnson, and he borrowed the money and he used it, and he invested he invested the product in Johnson business venture. That will not be an excuse. That excuse will not hold water. So he's personally liable. Even when you are running a sole proprietorship and you decide to register with CAC, it's still the same implication. You are personally liable. You are personally liable for any debt or anything. They will go after your belongings. So that is the implication of running a sole proprietorship. So that is it about sole proprietorship. But as I said, it's sole, as the name implies, one person running his business, one person enjoying the profit, one person making the decisions, one person doing whatever he likes. And we are going to look at partnership. We know, just as the name implies, partnership. That means one or two persons coming in together to run a business. They are coming in together to run a business. That is partnership for you. And partnership can be limited and it can be unlimited partnership. When we say limited partners, that means you are entering into that partnership with the aim of just investing. You don't want to be involved in the day-to-day running of that partnership. Mr. Johnson and Mr. John want to enter into partnership. And in the partnership agreement, Mr. John said he only wants to be a limited partner. That means he just wants to invest his money and sit back and sit back and enjoy the returns from his investment. He doesn't want to be involved in the running of the day-to-day running of the business. So because of that, he's a limited partner. But where Mr. John says he wants to engage in the day-to-day running of the business, then he becomes a general partner. And the difference between limited partner and general partner is that if you decide to be a limited partner, your liability is limited to your investment. Let's say Mr. John and Mr. Johnson are into partnership, and Mr. John is a limited partner, and Mr. Johnson went and borrowed money in the name of the business, in the name of the partnership. So because Mr. Johnson is a limited partner, what he will pay back where they're in default of that loan will just be limited to his investment in the business. The debtors cannot come after him and say they want to collect his personal belonging. He's limited to his business. So that is why here in the slide you can see I said general partners are at risk of having their personal belongings cease to offset the debt and liabilities of the partnership in the business. That is general partners. If you are into general partnership, then you know that they can come after you personally. But if it is limited, it's just limited to your investment. Then because it's a business made up of two or more partners, each sharing the profits, debts, liabilities, and assets. That is general partners. Then a limited partnership exists when two or more partners go into business together, where one or more of the partners are only liable up to the amount of investment. As I said, his liability is limited to his investment in the partnership. And one thing you need to know is that one thing with partnership, if you are going into partnership, you must agree to share the profit equally. So, in drafting your partnership agreement, you must decide that your the profit will be shared equally. If not, you are not entering into partnership with any person. If you are not sharing the profit equally, the determination of who is a partner is whether the person partakes in profit sharing. If you don't partake in profit sharing, forget it. You are not a partner in that business. If maybe things might not get to court. But when it goes to court, this is how court will interpret it. If you say you're a partner, they'll say, okay, how have you been sharing the profit equally? Have you been getting profit, or has he been giving you take this, take that? So if it is take this, take that, not that you share the profit equally, then you cannot regard yourself as partner in that business. Then we have companies. So there's something about companies are unique. The way companies are operated are unique. So let's say, for instance, now Mr. Johnson, instead of running a business name, then he decided, and sorry, let on sole proprietorship and partnership, you can decide to register a business name as a sole proprietor, and you can decide to register a business name with CAC as partners. You people as partners, you decide to go into business, then you can decide to register a company. With the newcomer too, you can also register a company as one director and one shareholder. But the problem is that I'll tell you the problem when we are discussing registration with CAC. We will still look at these things when we are discussing registration with CAC. So what is the once what is company? When you decide that you want to run a company, it's still a legitimate business venture that you are going into, that you want to make profit. So company, we have different types of company. We have private limited company, we have public limited company, we have unlimited company, we have company limited by guarantee. But for the purpose of this class, we'll just look at private limited company and public limited company. So once you decide which of the companies you want to register, especially if you're a small business, it's more advisable you register a private limited company. And the implication of registering that company is that once you decide that you want to register a company, let's use Mr. Johnson, who was running Johnson Business Ventures before. Then he decided that, okay, I don't want to run Johnson Business Ventures now. I want to run Johnson and Johnson Limited. I want to register Johnson Limited as a company. What happens is that from the date certificate of incorporation is issued to Mr. Johnson, the company becomes a separate corporate legal personality. It becomes a separate corporate legal personality. That means it becomes a separate human being of its own, separate from its shareholder. So that means anything Mr. Johnson is doing now he's not doing it for himself. Is anything Mr. Johnson is doing now in the name of the company, he's not doing it for himself. He is the company that is doing it. Because in law, the company is regarded as an artificial person. So shareholders of the company have limited liabilities. Because if you want to register a company, you must have the directors and you must have the shareholders. If Mr. Johnson decides that he wants to be a director in the company, he can be a director as well as a shareholder. So if there are liabilities, his liability is only limited to his shares in the company. His liability, unlike when he was running a business name, when he was running a sole proprietorship, when he was just running a business name, not when he decided to run a company, which is Johnson and Johnson Limited. So in such a case, his liabilities is only limited to his investment. When Johnson and Johnson Limited borrowed money from any, let's say for instance, Johnson and Johnson Limited borrows money from Skyron Bank Limited. Johnson and Johnson Limited will be held liable, not Mr. Johnson, even though it's Mr. Johnson that applied the loan in the name of Johnson and Johnson Limited. Mr. Johnson will not be held, will not be personally liable for that debt that Johnson and Johnson Limited is borrowing from the bank. It's Johnson and Johnson Limited that will be liable for that debt. Why? Because Johnson and Johnson Limited is considered an artificial person in law. So once you decide to register a company, that company becomes a separate person. It becomes separate from you. That's why here we have it that the personal assets of the shareholders cannot be seized to offset the debts and liabilities of the company. You get it? So because you're a shareholder in the company, once the company borrows money from GT and GT, you are unable to pay the money, GT has written to you severally, and if GT will be writing to you to either to management or director of Johnson and Johnson Limited or the director of that company, and you've refused to pay, and GT went to court, got judgment, and in executing that judgment, GT cannot come after your house, GT cannot come after your car. What GT will go for is anything that is in the name of Johnson and Johnson Limited, in the name of the company. So what is the implication of registering a company? What is the implication of Mr. Johnson deciding to register Johnson and Johnson Limited? By registering Johnson and Johnson Limited, that it means that Johnson and Johnson Limited can buy and own properties. That is why you see some certificate of occupancy carrying names of companies rather than names of individual. It can enter into contract. It's common for you to see different companies entering into contracts. It can be sued and be sued. It's common for you to see this company versus this company, because in law it is regarded to as an artificial person. Then it enjoys perpetual succession. That means it lives forever. The company can live except it becomes a no a it becomes is no longer a going concern. Maybe they are experiencing business and they decide to wind up, then that is when the company dies. But as long as the shareholders are there, then the company lives forever. Let me use this example. For instance, First Bank. If you check their logo, you see since 1959. Are you telling me that the people that started First Bank are still alive? No, because First Bank is an artificial person, so it lives forever. It enjoys perpetual succession. Different shareholders will come. So when you decide to register a company today, you can sell your shares and leave the company. The company will still be a going concern. You heard of pay stack. that was bought $200 million. So you see, Paystack is Paystack, but the owners now they've bought their shares in the company, maybe percentage of their shares. So as a result, they are leaving. They might not have that control they used to have over the company if they have not sold the whole of their shares. But if they've sold the whole of their shares in the company, they no longer have a say in the company because they are not shareholders. But I cannot say for them because I wasn't part of the deal. So it enjoys perpetual succession. What I'm trying to say is that Paystack will live forever as long as it's a going concern, just as First Bank is still carrying out business, even though the initial shareholders are dead. Then you can apply for loan in its registered name. So when Mr. Johnson decided to register Johnson and Johnson Limited, it means he can do any of the following. He can buy properties in the name of Johnson and Johnson Limited, can enter into contract in the name of Johnson, he can be sued and he can sue and be sued in the name of Johnson and Johnson Limited, enjoys Johnson and Johnson Limited enjoys perpetual succession. Johnson and Johnson Limited can apply for loan in its registered name with CAC. However, to every general rule, there is always an exception. There are situations that there will be lifting the veil, something we call in law lifting the veil. Where there is fraud, the court would like to know who are the persons behind this company. So when you decide to register a company and you commit fraud, don't say, the company is a separate legal person from me. It's the company that committed fraud. No, the law will not say so. The law will invoke the principles of lifting the veil to see who are the persons behind this company so that they could be punished for their act. So this is just the implication of registering uh, a company. We've seen the implications of what are the legal implications of registering sole proprietorship, partnership, and now company. So based on this, you decide which is best suited for you. Which one do you want to register? Which one do you want to run? If you want to run a sole proprietorship too, you can also register with CAC. If you want to run with a partnership with your friends or family, you can also register with CAC. But you cannot approach CAC and say, I want to register partnership. No, you can only register it as a business name or a company, or if you don't want to make profit, then you can register it as incorporated trustee. If you, but here we're talking about making profit, so we limit ourselves to private limited company, public limited company, or unlimited company. So the next we are going to talk about registration of business and non-business organization. So So why do you have to register your business? Registration of business is done as we've said with the CAC, as we've said, whether it be a business name or a company incorporation. Any business, whether small or large, will in the long run benefit from corporate and fiscal and product registration. So when you register your business, in the long run, you benefit from corporate and fiscal and product registration. Then, of recently, you heard that the federal government is registering 250,000 businesses. They will help people to register for free and also give them capital and the rest. All this the federal government is doing is to capture more people into the tax net. And of recent, you heard of the survival fund that is to be disbursed by the federal government. When your business is not registered and you don't pay tax, you don't expect to get such to benefit from such disbursement from federal government because your business is not registered and you don't pay tax. So you are not expected to benefit from such. But where your business is registered and you pay your taxes, if there are any incentives to be given out by government, then you definitely benefit from such incentives because one, your business is registered, two, you are paying tax. This is more common in abroad, especially during this COVID-19, when the COVID-19 pandemic was so high in Europe. You can see different economic packages uh, being distributed or being planned for businesses, small businesses in England. The the secretary in charge of business was busy coming up with policies that will ease the laws for small businesses. So when federal government wants to do something like that in Nigeria, and as the federal government is doing that, and your business is not registered, then you will not benefit from such. That's why we said unregistered business with corporate affairs is unknown in law, and therefore you cannot even transact some official businesses. You cannot even borrow money from bank because you're you are not registered. While unregistered product with NAFDAC will attract low patronage because believe me, if you want to buy a product, there's this consciousness that has been developed in you due to advert and direct. You want to buy a drug, or you want to buy a drug, or you want to buy sachet water. You say, let me check where's the NAFDAC number. So if you don't see NAFDAC registration number, you're likely not to buy that product because your in your mind you are already saying to yourself, this product is fake, because due to the awareness and the rest by NAFDAC that products should be registered with NAFDAC. So if you don't do what is expected of you, your business will not attract the patronage you are supposed to get. You'll be unable to borrow money. You will not benefit from certain incentives from the federal government. Registration is also an important social responsibility, both from a legal and moral angle. As the citizens, you have the obligation, as citizens of Nigeria, you have the obligations to pay your tax. So when you register your business and pay your tax, you are fulfilling your social responsibility. So we are going to discuss small business startup procedure. So small business startup procedure, you find a suitable business name to support your business idea. That means you're not into a business currently, you want to start. What are those things you have to consider? First of all, you find a suitable business name to support your business idea. Suitable name that relates to your business, so that by the time you tell me, I ask you what's the name of your company, or what's the name of your business, by the time you tell me from the name, I can be able to infer the kind of uh, business you are into or kind of services you are offering. Then you identify a suitable business location, a good location where there will be patronage, where you gain patronage too. You cannot go to a place where there are thousands of sachet water companies. Then you say you want to start sachet water company, except where your own sachet water, there is one distinguishing factor that will separate it from the rest. Then you can go and start there. But it's more advisable you look for a location where yes, one, people are in need of water, especially during dry season. Two, there are no much uh, businesses similar to the one you want to go into. Then you can start marketing your product there. Then another important thing is you register the name with Corporate Affairs Commission. Register it with Corporate Affairs. When we're discussing the registration with the Corporate Affairs Commission, you get to know how you do that. Make sure you choose a name that is easy to pronounce, remember, and has a relationship with your type of business. As I've said earlier, register with the Federal Inland Revenue Service as your value added tax. We talked of value added tax being administered by the Value Added Act, that Value Added Tax Act, which is administered by the FIRS. So you need to pay, which I said earlier, that is a consumption tax that is levied repeatedly on a product or service you offer. So if you are offering a service, you must charge VAT. If you are selling a product, you must charge VAT, because you must remit such to FIRS. Because if you failure to pay that, FIRS will come after you. They'll take you to court, and if the court sanction you pay, and in addition you pay penalty. So you need to register with the local VAT office so that you can remit your VAT. Register your product with NAFDAC, where what you are going into is something that is a product. It falls under a category of product that is administered by NAFDAC. Then you registered with the Standard Organization of Nigeria, where it falls in the product, or the product you want to manufacture falls into the inventory or list of products that has to be certified by Standard Organization of Nigeria. Then the part I've been saying will come to it, will come to it. So we are finally here, which is procedure for registration with NAFDAC, with the Corporate Affairs Commission. What are the documents? How will you go about registering your business name? Before I commence, I want to tell you that there are four categories of persons that can register your business for you with the CAC. The first is a lawyer. The second is a chartered secretary. The third is a chartered accountant. I didn't just say secretary, I said chartered secretary. I didn't just say accountant, I said chartered accountant. Then the fourth person is you. If you want to register yourself, you can do it yourself, because the CAC has made provision for such. But you don't say because you register for yourself, another person can come and meet you and say you want to register. But another card warning or something, if you want to register yourself, you need to know the procedure of registering. Because if you don't know the procedure of registering and you submit, or you don't meet the requirement for the registration, your company will not be registered and it will be queried by the CAC. And once it is queried, until you rectify the query before your company will be registered by the CAC, and you given certificate. So where you are not sure and you you know that you can't do it yourself, then you can hire an agent to do it. And who are the agents? Chartered secretary, chartered accountant, and a lawyer. These are the people that you can use. And before you can do that registration, you must have a CAC portal. You must create a CAC portal. These people already, I'm telling you, chartered secretary, chartered accountant, a lawyer, if he is an accredited agent with CAC, he already has a portal. So using that portal, he can reserve the name for you, or you, if you decide to create a portal as the owner of the business, you can reserve. The first thing you need to do is reservation of name. You reserve the name. After you've reserved the name is reserved for 60 days. And normally, if you want to reserve a name with the CAC, there are some procedures there are some things you need to know. The name must not be similar, the name must not be in use, the name must not be a name that is restricted, such as Chamber of Commerce, such as Abuja. For you to use such names, you have to obtain the consent of the particular organization you want to use their name. Let's say you want to use Abuja, you must go to AMAC and obtain the consent from whoever is in charge that you want to use AMAC for your business, and this is the reason. So you must make sure that the name you're about to enter does not fall into any of the categories I just said. So you submit the name for approval. Once you submit the name for approval, in 48 hours or in a day, not up to 48 hours, maybe that day you submit it, the CAC will give you either notice of denial or notice of approval. Notice of approval, that is, they are saying that the name has been approved. Notice of denial, the name has not been approved. Then they will give you the reason for not approving the name. Then where the name has been approved, the approval note will carry a code which you will enter and begin your registration online. Once you begin your registration, by the way, the site to do the CAC portal, once you go to www.cac, be it their homepage or the portal, it will take you to, once it will show you where you start your registration with, once you go to their site. So once you begin the registration, you enter all the necessary details, your name as the proprietor of the business, because we are talking about registering a business name here, not registering a company. You enter it as your name, or if you have more than one proprietor, the different proprietors, you state the nature of your business. Then you there are information on your there is an information on your page of the national identity card or driver's license or voter's card or international passport, which the CAC will require. So you need to impute that particular information. That's why you need either of these uh, national identity card, driver's license, voter's card, or international passport for you to carry out that registration. These are means of identification. Then you have your two passport size photograph, which after you must have completed the form. After completing the form on your computer or in your computer, you download the form. There's a place after downloading, you then sign. After you sign, then you upload the forms back. Or if there is a way you can crop the signature and put it there, you crop it and put it there. And the passport too, if you can crop it and put it there, then you can crop it and put it there. Then you can then upload the documents to CAC. But the normal procedure is you download the document, you sign. For business name, there is no need for notary public. Then you sign, then you upload the form back to CAC, and CAC will look at, will go through your application. If there is no problem, they will approve your application. And once they will tell you to come and your certificate, when your certificate is ready, they will communicate it to you. You go and pick it up. So that is it with the procedures and documents to be submitted to CAC for registration of a business name. An example of business name is examples of business names are Taiwan Co, Global Venture Farms. These are examples of business name, unlike companies that come with limited or PLC. So business names are, you can use your name, you can, so these are things you need to know about registration of business name with the Corporate Affairs Commission. So the next we are going to discuss is uh, documents to be submitted for registration of company. So once, just like business name, you've decided the name you want your company to be. But in the case of companies, the name of the company must carry limited. It must carry limited. And for the purpose of this class, I know most of you, if you want to go into business, it's a small business you go into. So the best you have to register is a private limited company. And a private limited company, by the old KAMA, must have 2 to 50 shareholders. But with this KAMA that has just been passed, but has not been implemented by CAC, you can have one director, you can have one shareholder for any company, be it private limited company, be it public limited company. But since CAC are still using the old, they are still implementing the old KAMA, we will still go by the old KAMA. When they begin to implement the new KAMA, then we will make changes and reflect the changes in the new KAMA. So for a private limited company, it has to have 2 to 50 shareholders only. You must have at least 2 to 50. It must not pass 50 shareholders. So if you want to register a company, you've gotten the name, you need to get who the directors are, who the shareholders are, who the secretary of the company will be, what the share capital of the company will be. You need to have this information. What are the objects of the company? What that objects will mean, what is the company going into? Is it production of chicken product? Whatever you are going into, you have to state the objects of the company. So these are things that if you can't do yourself, a lawyer is always there to guide you, who is accredited, a lawyer who is accredited with the Corporate Affairs Commission. So for the purpose of this class and from previous classes that you've had, I believe if you are to go into business now, is going to be into a small business. So if you want to register a company, it's advisable you register a private limited company. And the fact that you start with a private limited company does not mean you cannot upgrade the company subsequently to a public limited company. And for a public limited company, the shareholders have to be two to at least two, then unlimited, going by the old KAMA still. Then it must carry the name PLC. Public limited companies are usually quoted at stock exchange market and are highly regulated by Securities and Exchange Commission. So as I have been saying, a private limited company is more suited for small and medium businesses. So just like business name, the way we talked about, when you have decided that this is the name of my company, remember it must carry limited, private limited. Is it Johnson Nigerian Limited? Is it Johnson? The company must carry limited. If you want the name you are giving whoever is registering it for you, or if you are registering it, it must carry limited. Because if it doesn't carry limited, CSC will not even register you. So first of all, you've gotten the name, you submit the name for reservation, the proposed name you've gotten. Remember, it must not be a name that is in use. It must not be a restricted name. It must not be a name that is similar to another name that is in use, just like the business name. You submit either for approval, and is normally names are reserved for 60 days. So you have to commence your registration within 60 days and complete such registration within 60 days. But once you've commenced your registration and you've made payment, then the time stops running. You are no longer bound by that 60 days. You can register, you can continue your registration at any time. You can complete the registration. But if you have not made payment, is within that 60 days, you must complete your registration and make payment. Because if you don't complete if you don't make payment within that 60 days, you just find out everything that you've entered, even the name, has expired. So then anybody can take up the name. So once the name has been approved, just like business name, you enter the name of the company, the information of the shareholders, directors. And remember, it must be at least two directors, it must be at least two shareholders. Just like business name, photocopy of the information page of either your national identity card, driver's license, voters, or international passport of the directors, shareholders of the company. Evidence of consent where applicable, proficiency certificate, which the CAC does not require such, because these are things that are subject to policy. But as it is now, they don't require proficiency certificate is required. For example, you want to register a pharmacy, they will ask you to come with a certificate of somebody who is a pharmacist, or you want to register a you want to register a security company, they might ask you to come with the certificate of somebody who is either working with the DSS or the any security agency in Nigeria. Then you have the memorandum and articles of association. When we say memorandum, we're talking about these are memorandum contains the object of the companies and it regulates the relationship of the company with outsiders, while articles of association regulates the relationship, regulates the activities of the company within the company, is within the company, is the rules that guides the company on how they go about maybe transfer of shares to another person, how they go appointing directors and the rest. So this is articles of association. So all these things, by the time you fill the form, they are there for you. You'll be filling it stage by stage as online as you are filling it. So for the memorandum, you have to put in the objects yourself. But for the articles of association, CAC will give you one which you can adopt. You can adopt it, then subsequently, after you've registered your company, you can alter it or you can upload your own at the stage of but it saves you time when you adopt that of CAC. When maybe your company is growing, you can decide to alter it, then you can file it with CAC. Because after you register your company, there are certain things you still be doing with CAC. That is why while we were talking about the function, we said the CAC, one of the function of CAC is is management. So management and maintaining companies registry. So that's one of the function of CAC. So once you've completed the forms online, you download the form. In this case, you have to download the form so that the various shareholders and directors can sign. They will sign. You take it to a notary public or commissioner for oath who will stamp for you. After stamping, Then all their means of identification, be it national identity card, driver's license, voters or international passport, then you need to scan everything, then you upload it. There's a provision for uploading such documents. So this is it with registering procedure and documents to be submitted to CAC for registration of company. You may be thinking, oh, how can I remember all these things that the facilitator has just said? I said, if you can't do it yourself, there are agents, chartered accountants who are accredited with CAC, lawyers and the rest that can help you register your business. So these are fees for registration of companies under Part A. This is just for the purpose of this class, because the issue of fees with CAC is subject to policy change. These are things that can change at any time. And as I'm speaking to you, this is not the current fees for registration of 1 million shares. If I'm not mistaken, it's like 15,000. Then you have stamp duty for 8,000. Then you have remitter charges that will be charged. But for the purpose, this is just for there. And if you are registering more than 2 million, more than one share capital is not like you are paying say 1 million. No. Don't think if I say 1 million share capital, it's not like you're paying, it's just an artificial valuation of that company. You are saying your company is worth 1 million. That is what you are saying. So the shares of that company will be will be will be shared within that 1 million of that share capital. Let's say you have four shareholders in that company. So each person will have 200 million ordinary shares, 200 million ordinary shares of 1 naira each. So that is just the shares. So these are just fees that are just there for the purpose. So by the time you do the registration, you get to know the fees and everything. If you want to register a business name too, the fee currently I guess is 10,000 naira. That is the registration fee you pay to CAC. Then there are stamp duties and other things. If you are using a professional, that is the charter secretary, you know he will charge for his professional fee and the rest. And logistics too, downloading, uploading, these are things they consider. So basically this is it on registration of procedure for registration and submitting documents and documents to be submitted to CC. So finally, and the final topic we are going to discuss in our class today is law of contract. Why do you need to have an idea of law of contract? Because by the time you register your business, you will enter into negotiations, you will enter into different businesses with different people. So what is contract? When we say contract, we are talking about enforceable legal obligations agreed upon. One, you need to know it must be enforceable. Two, it must be illegal, just like your business organization. Any contract you're entering into, it must be a legal contract. Because once your contract is illegal, is invalid, the court will not enforce it. We'll look at example of an illegal contract subsequently. So what are the elements or what are the features of a valid contract? What the main features of a valid contract, the basic elements of a valid contract, the basic, there must be offer, acceptance, consideration, then others will follow. Then we'll start considering form, capacity, legality, intention to create, legal obligation. When we talk offer, offer can be in two ways. Offer is, let me use Mr. Johnson and Mr. John, for example. Mr. Johnson has a car, a BMW model X3. He wants to sell it to Mr. John. He approaches Mr. John that, Mr. John, I have a BMW, I want to sell it to you. That is offer. That is Mr. Johnson making offer to Mr. John of his BMW X3. Then offer too can be in such a way that, uh, for instance, taxi's driver, once you stand on the road, you are waiting for a taxi driver. If the taxi should stop for you, that is the taxi making an offer to you that he wants to take you to your decision. So that is also another way of offer. Another way of offer is contracts. You will see they will advertise on newspaper that they are calling for tenders. So these tenders is not offered. It's when you submit your tender, that is you are making an offer. So these are offer can be, excuse me, offer can be in different ways. So once there are offers, then there will be acceptance. So Mr. Johnson has coming to meet Mr. John that he wants to sell his BMW to him X3. Mr. John can decide to say I'm buying, and he can decide to say I'm not buying. If he says he's not buying, you cannot force him to buy. If Mr. John says he's buying, then there's what we call in law acceptance. But the contract is not complete until there has been consideration. And consideration is anything of value that has exchanged hands. That means money has exchanged hands. That means he has offered, he has accepted, and he has paid. Then you've met the basic elements of contract. Then we will say, finally, we can say there is a contract. Then once there is offer, there's acceptance, and there is no contract. And one thing with consideration, even if you say the product is going for 1 million, let's say Mr. Johnson wants to sell his X3 for 1 million, and he decides, and Mr. John accepted the offer, and he gives Mr. Johnson 100,000 out of that 1 million. In the eyes of the law, there is contract because consideration has passed. Because no matter how little the consideration is in the eyes of the law, especially when that 100,000 paid by Mr. John is is a part payment, not deposit, then the law will consider such as a contract. Then the law will consider the form of the contract. Is the contract written? Is it oral? Is it by conduct? Oral contracts. Every day we go into oral contracts. When we buy things from our common vendor, we're entering into oral contracts. Like, okay, excuse me, how much is this? She will tell you. This is you negotiate. This is you entering into oral contract. So if you look at your day-to-day life is contract, you are always entering into contract without even knowing the implication of what you are having yourself into. Maybe because we are not bothered, because maybe the amount where we are paying is not much and the rest. Then by conduct, contract too can be by conduct. For instance, now taxi drivers, you stop on the road. The taxi man, let's say you are coming from Jabi, you are going to Life Camp. You stop. The taxi man will use his hand to indicate that he's going straight, which you know is Jabi. You just enter. You will not say anything. You will just enter the car without even asking how much the amount is. Once they get to your destination, you remove 100 naira or 50 naira and give it to the man. That is contract by conduct. Already know what's said, but already there is a contract. The law will regard that as a contract. Then written is common, where you have it written. Even though the law that there are some contracts that the law will tell you it has to be in writing. So these are, then we go to capacity. Capacity is, we're saying, is that person capable of entering that contract? Is he of age? Does he have the mental capacity? All these are things you need to consider by the time you are entering a contract. Like a child who is under the age of 18, even though in Nigeria we don't have a particular age that we refer to as age of which will regard somebody to be an adult, but going by election, I think I'm safe to say 18 is the year by which somebody will be set in Nigeria to be an adult, because even drivers driving and the rest, they will say you must be 18. So if it's somebody who is under the age of 18, you enter into a contract with somebody who is under the age of 18, such contract can be regarded as null and void. Void from the instance, ab initio, as we say in law, from the beginning is void. But where that contract you enter with an underage person is for things of his necessities, that is things that pertain to, let's say, food, things, let's say, that are of necessity to him, then such contract can be regarded as legal. Where you enter into a contract with a mentally challenged person, such contracts are illegal except in his lucid period. You know, some people can be mentally challenged, but there are some periods that they are at their lucid period. That means they can reason normally, they can do things normal. So in such a period, when you enter a contract with such a person, such contract is legal. Then we have the issue of legality boils down on the capacity too. And the option, when I said your contract, for it to be enforceable, it must be a legal obligation. So it must be legal contract you're entering. For instance, a prostitute cannot sue somebody to court that she slept with him and he has refused to pay her uh, her money for the night, because that kind of contract from the beginning is illegal. So also where politicians will hire talks to go and and steal ballot boxes, you don't expect such talks to go to court where the politician promised to pay them 500 and now he's giving them 200. Such contracts from the beginning are, are illegal. So we also have the intention to create legal obligation. There must be this intention there that you want to create legal obligation. Both parties must agree that, okay, we want to create legal obligation. So once these elements are present, you have a valid contract. Then we'll look at privity of contract. When we say privity of contract in law, we're just simply saying only parties to a contract can sue. When Mr. John and Mr. Johnson were negotiating about the sale of his BMW X3, let's say there's a breach of contract. Maybe uh, Mr. Johnson, in the course after they've settled with Mr. Johnson and he has agreed that he will sell the uh, BMW X3 to Mr. John, and Mr. John has made payment, then Mr. Johnson will go ahead and sell it to another person because he has gotten higher money. So in this case, Mr. John can sue Mr. Johnson for breach of contract. And what privity of contract is saying that Mr. John's wife cannot sue on behalf of Mr. John because she wasn't part of that contract. So privity of contract is just saying only parties to a contract can sue. Only parties that are involved to a contract can sue. However, there are exceptions to this. There are exceptions to this general rule. It's a general rule, but there are exceptions. There are situations where parties who are not party to a contract can sue to enforce that contract, or whatever it is, be it breach of it, to obtain damages, compensation. So where a party is not party to the contract at the time of negotiation, privity of contract is saying there are exceptions where you can sue. Let me give you an example of an exception to privity of contract, where Mr. Johnson and Mr. John entered into a contract for, let's say Mr. John is an entertainer, so Mr. Johnson runs a theater. So Mr. John is supposed to come and be singing every day uh, uh, at the theater by 6 p.m. Then Mr. Uh, Mr. Mr. John's wife will come every time and be interfering with his performance. She will be interfering with the performance. She will not allow him to perform. Even though the contract Mr. Johnson entered was with Mr. John, which by privity of contract, only Mr. Johnson can only sue Mr. John because that's the only person he entered into contract with. But in this case, the law is saying Mr. Johnson can sue the wife for interfering with his right because she knows that Mr. John has already entered into contract with Mr. Johnson. Why is she coming to disturb him from performing that contract? So in such a case, the principle of privity of contract will not apply. Then we have terms of contract. When we talk of terms of contract, we are saying the terms in which you are entering a contract. What are the terms? Maybe the terms of one contract is the person is not going to build a house, the person is not going to buy a car, the person is not going to use the company to work. So these are terms. So we're saying these terms can be expressed and they can be implied. Express is that it is written there, blue and white for a person to see on a paper that these are the terms. Implied is that, for instance, Mr. John is selling that BMW X3. There is this implied, even though it might not be expressly stated, maybe let's say they've drafted an agreement in the agreement, but there is an implied term that as of the time he's selling that BMW X3 to to Mr. John, that BMW is in good shape. So where he finds out that the BMW is not in good shape, then he can sue for anything breach, even though the law is saying that court will not interfere, court will not normally imply terms to contracts where parties have decided these are the terms of the contract. So it is advisable when you are entering into a contract, make all the terms express. Don't leave any term. Anything you have in your mind that you feel should be included, all should be included. So these are just it on terms of the contract. Then we have vitiating element in a contract. What are those things that can vitiate a contract? We have duress. Duress is you are threatening the person, direct threat of violence on the person, that if he doesn't carry out that contract, you're either going to harm him or you harm a member of his family. So in such a case, that is duress, and in such case, such contracts can be vitiated. Then we have undue influence. Undue influence can be where you have a special relationship with the person. That means there's a fiduciary relationship. Maybe you are the person's banker and you made the person to go using your influence on the banker, you made the person to enter into a contract, and in the end, the contract is not beneficial to that person. In such a case, in such a case, that contract will be vitiated because you used your undue influence to influence that particular person to enter into that contract. Undue influence too can be in such a situation where you are threatening the person that if he doesn't enter into this contract, that you have the capacity to make somebody not liable for liability for the contract, but liable for consequences of that contract. Then we have unlawful termination. Unlawful termination is where sorry about that. So as I was saying, misrepresentation, when you don't state the true facts of what is it you're about to sell to the person, and you misrepresent the true position of fact, and you made that person to enter such into such contract. Such contract is, it will be vitiated by law. Then we have mistake. Mistake in the sense that at the as at the time parties were negotiating the contract, unknown to them that the subject matter of the contract is no longer in existence. That is what we call mutual mistake in law. Let's say Mr. Johnson and Mr. John are negotiating for the sale of a filling station in Gwagwalada, unknown to them that there has been a storm in Gwagwalada that has destroyed the filling station. In that case, there is a mistake. That is what we call a mutual a mistake in law. A mistake has occurred in law. So both parties unaware to them that the subject matter of the contract is no longer in existence. So in such a case, that contract cannot be said to be valid, even though payment has been made, as long as the uh, subject matter of the contract is no longer in existence as of the time of the discussion. So you see, another form of mistake in law is the fact that, let's say Mr. Johnson has two cars, a BMW and Mercedes. He wants to sell the BMW for 40,000, the Mercedes for 50,000. Then he approached Mr. John. Mr. John thought that, okay, Mr. Johnson wants to sell the two cars for 50,000. Unknown to him that Mr. John is saying, no, the Mercedes is 50,000. So in such a case, there's also a mistake. Such contract too can be vitiated by law. Then we have what we call unilateral mistake. That is when one party, let's say Mr. Johnson runs a car dealer, or he runs a company where he sells car. Then Mr. John misrepresented himself as a member of Dangote groups, and they need a car urgently. The way he presented himself to Mr. Johnson is like, yes, he's from Dangote Group, so he was able to get a BMW from the stand. So in such a case, such contract cannot be legal. Such contract is illegal because there's mistake there. So that is it on vitiating element in a contract. Then we'll look at discharge of contract. When we say discharge of contract, that means when contract can be said not to be in existence. Parties are saying the contract has ended. So contract can be ended by performance. When parties have performed their part of the obligation of the contract, it can said to be discharged. So that contract is discharged. That contract is no longer in existence. That contract, parties have done away, they've performed their own part. Mr. Johnson has performed his own part of the contract, Mr. John has performed his own part of the contract, and in such a case, parties can say the contract has been discharged by performance. Then frustration, using the example of the filling station, where the subject matter of the contract is no longer in existence. Then such contract can said to be discharged by frustration. Then the issue of fundamental breach. Let's say you order for a phone from you order for iPhone phone 7 from from Jumia, then they supply you with the HTC phone. So there has been a fundamental breach of that contract, because what you asked for is an iPhone 7 and they are giving you HTC. So in such a case, that contract has been discharged by breach, by fundamental breach. Or parties can simply agree that, okay, even though they've not discharged the contract, or they've began the contract, then suddenly something happened, they can decide between themselves that, okay, we are no longer interested in going forward with this contract, so we want the contract to end. That is and discharged by mutual agreement. Parties are saying the contract should end by mutual agreement. That means none of the party is carrying any grudge that the contract has ended, because they both agreed that this is what they want. The contract should be discharged by them. So without even completing it or without even doing anything. Finally, under the law of contract, we discuss breach of contract. What are the remedies for breach of contract? We have damages. When we say damages, we are talking about compensation, monetary compensation paid to either party that has suffered damages as a result of breach of that contract. That contract between Mr. John and Mr. Johnson for the sale of the BMW. Let's say, for instance, Mr. Johnson, based on the fact that he's getting that BMW, he has done some dealings based on the fact that he will be driving to one event using that BMW, and in the end, the BMW wasn't sold to him. In that case, he can sue for damages for breach of contract, and court will pay him for damages. And damages can be specific and it can be general. Specific in the sense that you tell the court that I've lost a bag of rice, which is 5,000. Then you ask court to pay for that five. General is just you are saying yes, you've suffered damages, but it cannot be quantified. But you are entitled to certain amount. You have specific performance. Specific performance is just telling that you're asking the court to ask the other party to complete his own obligation. You are telling the court to ask the other party to perform his own part of the obligation. Let's say where Mr. Johnson has agreed to sell the BMW to Mr. John, and Mr. John has already paid part payment. The Mr. John can approach the court and said, look, oh, I've paid this man his money, all the elements of contract are present. I want him to release the car to me. So in this case, that is Mr. John asking for specific performance. Ratification is in the sense that the court will just alter the terms of the contract. Instead of the court to say to, now that he has sold the car to somebody, not to you, Mr. John, why not pay pay you your money back, and in addition, he will pay you damages. So the court has ratified the contract a little. That is what we call ratification. Then we have injunction. Injunction is in the sense that you are stopping a party from doing a thing. Sometimes it can be telling a party to do a thing, depending on the circumstances of the case. So, like Mr. Johnson and Mr. John now, he can ask the court to stop Mr. Johnson from selling the BMW to another person. That is injunction. When we talk of quantum merit, we're talking about, you are saying that you are entitled to you are entitled to payment for the services you've offered so far. That is why it's reasonable value for service. Let's say a taxi man picking you from area 1 to, and the intention was to bring you to Beggar, and the car spoiled at Buse. So if, sorry, from he's taking you from Buse to Life Car, and the car stopped at Jabi. So reasonably, you are expected to pay him for that journey from Wuse to Jabi where the car spoiled. So that is what we call the driver is entitled. That is why we said the driver is entitled to quantum merit. So parties can approach court for such that we can entitled to the reasonable value of service that I've offered to you. Then finally we have rescission. Rescission is canceling the contract, saying you are no longer interested. You don't have anything to do with the contract. So thank you very much. This is the end of today's class. Uh, we've discussed all the things I said we'll discuss in today's topic, which is, if you began the class with me, which I listed at the beginning of the class, and I believe uh, participants will be able to, if asked any questions on these things, will be able to give an answer, especially on the basic understanding of nature of legal system in Nigeria. I hope participants understand the legal regime and regulatory agencies regulating businesses, for the types of business organization and steps in the formation and registration of business, and understand the basic natures and elements in a commercial contract. So this is it. If there are any questions, observation, uh, any anything somebody wants to add, or there's a correction to anything I've said, this is the time to ask your questions. You can unmute your mic, your videos, so that I can see you. And if somebody is raising his hand or the person has any question, this is the time
Good
to ask.
afternoon.
Good afternoon.
Good
Please, who's
afternoon.
speaking? Please, who's speaking?
Good afternoon.
Good afternoon. I can hear you.
It's Manuel.
Okay, Manuel.
I want to really get or confirm the fee for registration. Is it actually 10,000? Because I have a chat previously with my friend concerning registration. He told
Hmm.
me that he knew someone that registered his own for 500,000. But on this class now, I get to know that it's not even close to that amount. Is it actually the 10,000 for registration in CAC?
What you want to register? Is it a business name or a company?
It's a business.
Business name. One, you need to
Okay.
know the person you are approaching for your registration. As I said to you, there are 4 categories of person that can do registration: chartered secretary, chartered accountant, a lawyer, and you, the person, the proprietor of the business. You get it?
Yes.
But the registration fee you have to pay to CAC is 10,000 naira for business name. You get it?
Yes, sir.
But if you're approaching any professional, he's not doing the work for you for free. He has to charge you for his services that he's offering to you. Maybe he has a way of getting the document across to you within a short period of time and the rest. So the fees they will charge you will be based on the services they will be offering to you. But for now, and uh, fees to be paid to CAC are something that are subject to change. If you want to register a business name with CAC, is 10,000 naira. That's the fee. But you know that if you are hiring, if you are asking somebody to do it for you, an agent, an accredited agent, you know he has to put in logistic, he has to put in other things, he has to put in so many things. It's professional fee in it. So maybe the person, that particular person you spoke with, contacted, that's his own fee for registration of business name. So that's just it. Thank you.
Okay, thank you very much, sir.
You're welcome.
And secondly, sir,
Hmm.
is it possible for one to register two business under one name?
That is not possible. Two businesses under one name. You will be you will be you'll be contravening the provision
Huh?
that says names should
Ah,
not be
you don't start
similar.
carton now.
Names should not be, because if you are trying to register two names, okay, if you are trying to register two names, two similar names, that means there is name similarity. It's not going to go through, because once you've registered the first name, if you want to submit the second name for CAC to approve, they will tell you no, there's already in existence a name that you want them to approve for you to register. Thank you. Any question? Another
Yes,
question?
please, I have a question.
Okay. Your name, please.
Yusuf Suleiman.
Okay, Yusuf Suleiman. Okay.
Uh, there's, can I say,
Sorry.
uh, if probably that I registered a CAC, that's a business name anyway under the CAC,
Mm.
and along the line when the business starts to move, and then I have a friend or a partner who wants to invest in the business, who wants to come and
In
coexist in
as a
the
part.
business, and the person wants his or her name to be on the
Registration.
yes, on like the same
I
owner.
understand what you are saying as a proprietor in the
Yes, so
company's registry.
these things, what would I do?
Mr. Yusuf, I can't
Yes,
hear you. I didn't get the last part of the question. But I guess what you are trying to say is that how can you bring in the person into the business for his name to reflect as a proprietor in the business? There are
yes,
procedures too for doing so. The fact that you registered a company with CC does not mean you cannot alter it. There's what we call post incorporation. So there are procedure that is already laid down for doing so. You can bring in the person as a proprietor in the business.
okay. So how do I do that if I may ask?
You have to use your this, unfortunately for post incorporations, you as an individual, you can't do it. You can only use a lawyer
Okay,
or an accredited agent to do that for you, to do the post incorporations for you, because there are some things that they will need an accredited agent to be the one to fill in.
oh,
So you get it. So once you contact that person knows how to go about it. But there are forms to be filled that you download from CAC website. Then there is a letter I think the proprietor will write telling CAC that he wants to bring in this person as a proprietor in his business. So once you fill in the form, you there are fees to be paid, and there are the fee for the post incorporation and the professional fee to be paid for the work. So by the time the person will file it, then if you need the certified true copy of that proprietor's form to show you that okay, that person has been included as a proprietor, to show the person as evidence, that agent that helped you to file for the post incorporation, that helped you to file for the addition of proprietor, will get the CTC copy of that document from you, from CAT, from CAC, certified by them, the CTC, to show that this document is not fake, it's coming from from CAC. So it will be in your company's file with CAC. If the person is doubting, he can pay for what we call search. In addition, he can conduct search with CAC. And CAC, if we tell him that, okay, his name has been added as a proprietor in that business. And let me add this, and your business name, you can upgrade it to a company too, if you want to. There are laid down procedures too for doing such. Thank you.
Okay. Yeah. Thank you very much.
You're
What
welcome.
about this? What about if? What about this letter of Anthony?
Okay, power of attorney. Power
Yeah,
of attorney. Power of
can
attorney.
that also be?
Can you repeat your question? I can't hear you. Can you please repeat your question? Because as you were talking, you just went off.
The power of Anthony. Can it
Attorney.
also be used by the Anthony? Can it also be used by the business partner?
Well, power of attorneys are usually in law, they are usually used when somebody wants somebody to act on his behalf. You get it? If it is partnership you are entering, I don't think you need to start drafting power of attorney. Rather, you should uh, do a partnership agreement between you and the person that this is the business you intend to enter. And this is because power of attorney is usually used in the case of land, or if the person has a property that he wants you to manage, he can draft the power of attorney and say, okay, I hereby donate my power with respect to property located in plot so to Yusuf Suleiman to act in my state to do the following. So to do the following will list what are the powers he has given you to do regarding that particular property or that particular land. Or like in the case of that NAFDAC now, the power of attorney will state that, okay, this Pfizer Nigeria Limited or Pfizer Nigeria is giving power to Yusuf Suleiman to one, sell and distribute their drug in Nigeria. So you get it, to just list what they want you to do. So you cannot exceed anything that is not contained in that power of attorney. Okay, that's just power of attorney there. So it's not like something you say you want to use. If you are going into business with somebody, you draft a partnership agreement, then you go ahead and either register a company or a business
You know,
name.
Sam, do that pattern now.
Another question, please.
Thank you very much.
Sorry, Mr. Yusuf, I hope you are okay. You are
Yes, yes,
satisfied with it.
yes,
Okay,
yes. Yes.
another question, please, if there is. They're going to be prison. Okay. In the absence of any question, we've come to the end of today's class, but our coordinator will be giving his closing remarks, and there will be a quiz. There will be a quiz after his closing remarks. So I hand you over to our coordinator. Thank you, sir.
Thank you very much, Barisa, for me. Good afternoon, ladies and gentlemen. It's a pleasure to be with you this afternoon once again. I'm sure that you are all thrilled with the presentation, the business law presentation this morning, running into afternoon. Let's give our facilitator, Barisa Johanna, for me a round of applause. Let me hear you. I can see your faces. Let me hear the applause. All right. So thank you very much, Barisa. I appreciate it a lot. I will be with Barisa again next week for a continuation of the program. Having said that, let me thank you all immensely for being a part of our week. It's been 5 days of very intensive training, and I hope that you have all benefited substantially from this program this week. We are looking forward to further engagement with you going forward. We have come to the end of the 5 days training. Tomorrow, we normally hold our graduation. Hold our graduation ceremony. It's online. It's an online graduation, and we are not going to meet on the Zoom platform as we are today. What we simply do is to send in some speeches, make some speeches, and then after that, we release your certificates. They will open the class by 12 noon, and by 1, the certificates will have been distributed. And then after a while, we close we do the ceremony, and then after that, the certificates will be distributed. That's the trend. And then what we'll do, we try to encourage our members, those who are already in business and who are already producing some items or who have innovations, or people like who are maybe into fashion design that want to exhibit their things. We open the platform, the training platform that we have today, where we've been communicating with you. We'll give you the opportunity of exhibiting your products. Okay, those who are into farming, who want to show us their poultry farms, for example, can do that. Who want to show us their fish ponds, they can do that. Who are farmers who want to show us their farms, they can do that. Who are dressmakers, fashion people want to show us their dresses, the dresses they've made, they're free to do that. Who are into catering, want to show us their cakes and then the food and all of the things they make, and then their restaurant, they're free to do that. So we'll leave that platform open on Saturday until the next Monday when we close that aspect of the exhibition. That is to provide members with the opportunity of getting to know themselves, seeing their line of business, and being able to recommend themselves for other businesses down the line. Such platform has, over the months that we have been doing this, helped substantially. People have been engaging themselves and then helping each other in marketing their products. I know somebody who was into courier service, logistics, and his colleagues, the moment they posted on the platform who has a logistics service, this delivery service, and so many came up, and then they started patronizing each other. And others, of course, were recommending their colleagues who are into events management and catering services to patronize their products. So that's the opportunity that this exhibition provides for members. So welcome you to exhibit your products, okay? All right, so having said this, I've come finally to the end of the program, and then plead with you to look forward to engaging with us tomorrow when we'll send, we'll do our graduation ceremony and then release our certificates to you. Those of you who we are consulting for the business plans, we ask that you please complete your forms and send them in good time so that we'll be able to do that. We don't want a situation when some people have already have been invited for interview, and then others are simply saying, what's happening? We haven't had anything. Meanwhile, they didn't complete their forms in good time and return for us to be able to process for them. So try and do that as early as possible and send it. If you have any problem, any challenges, get across to us. We'll try and help you explain it. I've already sent quite a number of those forms to some of your members on this class. After my program yesterday, my topic yesterday, they all sent asked that I should forward the forms to them, and I have done that. Okay, so those who haven't and they want us to consult for them, they should please do that. But if you want to do it yourself, we've already given you an idea of how to go about it, and I'm sure you'll be able to do it on your own also. All right, having said that, let me thank you immensely once again for the opportunity of being of service to you, spending this past 5 days with you. For us, it has been quite rewarding. I'm sure my colleagues and I were definitely benefited from you, from the questions that you've asked, which are sources of insights for us and other angles that we look at the subjects that we present to you. And we also hope that at the end of it all, you will have benefited from the training that you've had with us this last 5 days. On this note, let me once again thank you immensely. Unless anybody has any other question or anything to say, if not, then let me say thank you immensely, and then hope we'll see you some other time soon. And then feel free at any time to reach us. We'll be there to serve you. Thank you very much. Bye-bye.